Hey, I'm firearms attorney Gilbert Ambler, and I'm back today to talk about some welcome news from the Department of Justice, which is a new rule announced which is going to provide a path forwards for certain felons to restore gun rights. Now, if you're in a state that has been friendly towards restoring the gun rights of felons, you might not think this is a big deal, but we're going to talk through who this will matter for, and we're going to talk through why this is so important today. At the outset, I'll note there's two different types of felonies to concern yourself with. The first is going to be a federal felony, a federal crime that you were convicted of. The second would be a state-based felony. If you were previously, at least from 1992 through present day, convicted of a federal felony, there had really only been two paths towards restoring your gun rights. One path would be as-applied litigation. This as-applied path really opened up in the aftermath of Brune. Think cases like the Range case from the Third Circuit, where you would argue, although the law says I'm ineligible to possess firearms as a felon, really that law shouldn't apply to me because I'm a nonviolent felon. And for those folks, it was a viable path forward, although albeit an expensive and time-consuming path forwards. The other path forwards for a federally convicted felon would have been to pursue a presidential pardon, which would restore gun rights. However, for most folks, that is a long shot. There is, on the books, a third way that federal felons could restore gun rights, and that is the way that is now opening up once again. We're going to talk about that today. The second type of felon is not a federal felon, but instead a state-based felon. And if you were convicted of a state-based felony, in almost every state, you would trigger a state prohibition on your gun rights, as well as automatically trigger the federal prohibition on your gun rights under 18 U.S.C. 922. Pursuant to 18 U.S.C. 921, if the state that convicted you restored your gun rights, the federal government would automatically recognize that restoration. Now, there are some caveats or some nuances to that. There are certain states where the federal government has said, yes, although you say you're restoring gun rights, we don't think what you're doing actually counts or actually meets the statutes. I think Wyoming is a good example of that. As I understand it, Wyoming had an expungement procedure that was supposed to restore gun rights. The federal government looked at it and said, we don't think this expungement procedure is a true expungement, and therefore we don't think gun rights are actually restored. What the Department of Justice has just done is they have gone back to the third avenue that was available under federal law and would also be available for a state-based felon to restore their federal rights, which is 18 U.S.C. 925. Now, before we dive into exactly what this does, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. 18 U.S.C. 925 is a process by which the Attorney General can restore someone's federal gun rights. The problem with 18 U.S.C. 925 is that the authority under it had been delegated by the Attorney General to the ATF. And back in 1992, Congress looked at the amount of time ATF was spending on this, and the Congress said, look, you're spending approximately 40 man years, not man hours, but 40 man years of time every year doing gun rights restorations, ATF, and we don't want you doing that. We want you focusing on crime fighting, and therefore Congress prohibited ATF from using any funds in order to restore gun rights. So between 1992 and 2025, there was this federal law in the books, 18 U.S.C. 925, that said you could go through the federal government to have your federal gun rights restored, and yet the federal government had the Attorney General, who had that authority, had delegated it to the ATF, and the ATF had no funding to actually do anything with that authority, so there were no federal restorations processed, and that left those two long shot categories that we talked about, which is the pardon or the as-applied legal challenge. Fast forwards to this year, and after the past how many years under the Biden administration of anti-gun rules, we have a pro-gun rule dropped by the Trump administration, which is a welcome relief. This rule, effective March 20th of this year, 2025, removes and revokes the delegation of authority that the Attorney General had offered to the ATF telling the ATF it is no longer your job. You no longer have been delegated the authority to handle these gun rights restorations. Instead, that authority is going to go back to the Attorney General's office. And the Attorney General will either process them and come up with a process for handling these, or potentially could in the future delegate that authority to another department or agency that would have the funding to act under it, such as the Secretary of Treasury. Now, what does this mean? Well, if you had that state-based felony and you were in a state that was unhelpful, for example, to put this in perspective, here in Virginia, very easy. If you've got a state-based felony, we can help you. We can go before a circuit court judge, restore your gun rights with a circuit court judge ruling. If, however, you were up the road in Pennsylvania, restoration was far more difficult because Pennsylvania's gun rights restoration from a felony would have been either to pursue a pardon, which was, again, a governor's pardon, a time-consuming and expensive process, or you could apply for and receive relief under Pennsylvania law. The problem was the federal government wasn't going to recognize that relief. So what this process does is if you are a convicted felon in Pennsylvania, you can now apply for and receive the federal restoration, which will restore your federal gun rights. It means when you go to the gun store and fill out the 4473, the federal form, you will be eligible to possess and purchase a firearm if you receive that relief. And then once you have that federal relief, you can apply for under 6105D of Pennsylvania law, a state-based restoration, which will fix your state-based rights as well. And once you have both your federal and state-based rights restored, you would once again become eligible to possess a firearm. I understand this is a little bit confusing, but the important thing to note is that this process has been opened up. And I also should head off because I'm going to see somebody in the comments say they don't like to see felons getting their gun rights restored. I firmly disagree with this. My position on this, if you are so dangerous that you are a threat to society and we can't trust you, then I want you to be locked up. If, however, you are released out in public, and especially released and not subject to court supervision, meaning not subject to probation, not subject to parole, then I want you to have your gun rights back. Because essentially by releasing you, we have said we trust you to be out amongst us in society. And if we trust you, I believe that if you wanted to do harm, you will find a way to do harm. And so if we trust you to be out amongst us, I want you to have the same gun rights, as the same constitutional rights as anybody else. I want you to have your gun rights back. In fact, I would support a procedure wherein once you're released and no longer subject to court supervision, your gun rights were automatically returned to you. That way you didn't have to hire and pay guys like me money to help you get your gun rights back. Because unfortunately, in many of these jurisdictions, when you apply for gun rights back, prosecutors will oppose your restoration and will try to keep you from getting gun rights back. That being said, very exciting news, because all of a sudden, if you were in a state that either didn't have a procedure or didn't have a viable procedure, like Pennsylvania, where there was not a good procedure for the state-based restoration to trigger the federal restoration under 18 U.S.C. 921, or if you were in a state that didn't have a procedure, period, available to restore gun rights after a felony, all of a sudden, good news, the federal government is providing a path. Now, it is worth noting if you are in a state that both has a state-based prohibition on felons possessing firearms and no state-based remedy to restore rights, you still need to be cautious, because potentially you could have your federal rights restored and still be considered a felon by the state. I think that's going to be a small subset of states that fall into that concern. If you enjoyed this content, go ahead, hit that subscribe button. By the way, if you need a lawyer to help you through this process, if you are in either Pennsylvania or in Virginia for that matter, please reach out to my office. If you're in another state and you've got questions, we can hopefully get you in touch with a qualified attorney. Again, if you enjoyed this content, please hit that subscribe button. Until next time.